A very good evening to one and all. Welcome to today's resource person, Mr. M.S. Bharath, the founder of KRIA IP, and he is going to speak on a very interesting topic, namely the non-conventional trademarks. And I would like my colleague, Dr. Irfan Abbas, to give a brief introduction of sir. Of course, he needs no introduction in the world of IP, but a formal introduction for the benefit of our participants in this weekly online series. Now, over to Dr. Irfan Abbas, please.
Good evening to all the participants for the New Year IP Week 24 lecture on the topic of non-conventional trademarks. Today we have with us the resource person, Mr. M.S. Bharath. Sir is the founder of KRIA Law. Sir has founded KRIA Law in March 2021 after 20 years of practice and 12 years of leading a regional office as a senior partner of a large Indian IP firm. Sir is also fondly referred to as MS and is a sort of the litigator, strategist, counselor in intellectual property, e-commerce, technology, software, franchising and licensing, spanning numerous industries, and has mentored several hundred startups. In 2020, the Indian National Bar Association nominated him as the IPR Lawyer of the Year. In the 2019, he was nominated by the Indian chapter of Asia Patent Attorneys Association to represent India as one of the counselors. Sir currently serves as officer on several international IP organizations, such as member of India Global Advisory Council of International Trademarks Association, INTA, since 2015, and is a counselor of Asian Patents Attorneys Association, current president of IP Association of South India. Bharath sir is also a regular IPR and journal legal resource person at Indian Institute of Technology Madras, Research Park and ITM. In 2019, sir was one of the resource persons for the annual meeting of Society for Technology Management, STEM, a non-profit organization which aims to provide a facilitative environment for technology transfer processes. In 2016, sir was appointed as amicus curiae to assist the Madras High Court in the case of Hindustan Unilever Limited versus Andhra Detergent. With respect to the subject matter of territorial jurisdiction of the court, in light of Supreme Court decision in IPRs versus Sanjay Dalia and numerous cases of Delhi and Mumbai High Court, I request you to please address the audience.
Thank you, sir. Thank you. Good evening, one and all. I would like to start off by thanking my colleagues who have put together additional slides to my usual presentation, especially Ms. Reshma and some of the interns who have been working with us for the last 1 month. Giving a perspective from the view from a marketplace so that it's easy for all of you to understand how customers and consumers perceive brands on a daily basis. In a very basic level, a brand is required so that persons know. I mean, it's like a name of an organization or the face of the organization. In our legal term, we call it as though it's called a source identifier or the connection between the consumer and the company. So if you walk into a very big store, you will be flooded with brand names or trademarks, which can be a word or a symbol or a phrase or a design or combination of anything for that matter. So as long as it is graphically representable and is represented graphically, the Indian Trademarks Act would seek or grant you a registration as long as the brand or the trademark can be distinguished from your competitor. So as I said, imagine you walk into a departmental store. The number of brands which are there around or options which are there, you can see the color combination which are there, you can see the shape of the product which is there. Each of these are actually a method by which the company will attract you to pick up the product. So in a crowded marketplace, trademarks help the company stand out and attract the customer. So that's what a brand should do. It should not be confusing. It should not be generic. It should not be common. It should stand out. It should be unique. That's the whole point. Otherwise, you will get lost in this huge crowded marketplace. So imagine you start the day, you want to brush your teeth, you are spoiled with choices, whether it's Close-Up, Colgate, Pepsodent, whether it's a toothpaste or a tooth powder, and then you pick up your phone. It can be a Samsung phone or an LG or a iPhone or whatever it is. These are all brands. And inside that phone, you can have Aircel, Airtel, Vodafone. Those are service brands. And then if you want to go to college or you want to go to work, you get into a car cab, which can be a Uber or a Ola or a Meru. These are also service marks. They are not selling cars. They are not owning the taxis also, but they are aggregators of these service providers in a mobile app. That's also a service mark. Next example, if you look at it, is Suzuki or Maruti Suzuki. Suzuki standalone is a Japanese brand, but when it came into India, they teamed up with the Indian government in the 1980s and 90s and launched something called a hybrid trademark called Maruti Suzuki, like what Hero Honda is there, or Tata and AIG got together for insurance is there. And Avin in Tamil Nadu, that example we could have kept it for Andhra, but in Karnataka it's Nandini, in North India it is Mother Dairy, in Chennai, Madras it's Avin, all the in Gujarat it is Amul, the state-owned milk product company. And then comes certification mark. Certification mark means the owner of the certification mark, say the government of India in this case, owns Silk Mark and Khadi. They do not trade in those goods. They are only there to certify if products are meeting certain standards, they meet certain quality requirements, and then they allow others to use Silk Mark and Khadi. Just like your ISI mark or UG mark, as an agriculture mark is called UG mark for food products. ISI is there invariably for electrical and electronic goods. So if you see from left to right, top to bottom, you have FMCG as in fast moving consumer goods like toothpaste, white goods, which are electronic goods, which are mobile phones. You have large automobile mechanical companies like Suzuki. You have milk and food companies like Avin, and you have certification mark like Silk Mark or Khadi. So these are traditional brands which are on physical products or on service marks. But today, in the next half an hour to 40 minutes, we are only trying to see what are non-conventional, as in unconventional trademarks. So as I said earlier, before we get into non-conventional trademarks, one needs to know how to choose a brand. Choosing a brand is always a fight between two big departments in a company. The marketing department always in a company wants something which is very, very generic, very easy for the consumer to understand, for consumer to remember, so easy to market and advertise. But on the other hand, the legal team will say generic brands are bad, do not register. That's always a fight. But generic brands are bad brands for a lawyer or an IP lawyer because they are extremely difficult to protect. They cannot be protected They cannot be registered. Even if a company or a business uses these generic brands or generic words like great, best, or classic, it is no use using that generic words, because even after using them for 10 years, for 15 years, they cannot be registered. If a third party copies or uses the same word, you cannot stop them, because they also need to use those words. Next comes a slightly better version, but not so great in terms of strength of the brand, are the descriptive words like power. Power soap is there, or Surf Excel, Surf Power is there. That sub-brand power is very difficult to protect. But after some 5 years, 6 years of use, you can possibly say that it has become a protectable trademark. Then comes the same example like creamy herb. It is descriptive. It is a spread of what goes on your morning toast, and it is both made of herbs like mint or coriander, and it is creamy because it is made of mayo. So creamy herb is descriptive, but it takes a long time, a lot of money to make it acquire distinctiveness and then having a secondary meaning for persons to say, yes, this is a trademark. Then midway are much better brands, which are called suggestive brands, like Sunola or Sundrop. Sundrop is like drop of sunflower oil. Then duckback. Duckback means the bird duck, its back does not have any stickiness to it. It repels water. So for raincoats, it's a beautiful brand called Duckback, which means that the water slides away, but it does not describe the product. It is suggestive of the product. So that brand is much better than generic and descriptive brands, but it is halfway there. Then comes arbitrary words. These are dictionary words, but they have no meaning or not even a suggestion towards what product or service they are used for. Like say Apple towards phones, watches, and laptops. Apple is a food product or a fruit, or indigo for airlines. Indigo is a color, probably the color of the airlines also, but it has nothing to do with the service of airline. So this is also a much, much, much better brand, because even though the words are known words, they are nothing describing or suggestive about the products or service under them. Last, or the best way of branding, are invented words, which means that they are not there in dictionary. You try to put together some words, squeeze them, jumble the words and letters, or invent a word like Swiggy or Zomato. They were not there in any parlance or usage before they were invented. So if you look at this left to right in the screen today, the left side are what the marketing department will ask you to use. The right side is what the legal department would ask you to register or adopt. Not always everyone can come out with invented words. So a lot of brands will invariably be in the middle, either descriptive, suggestive, or arbitrary. A rare portion, very, very minuscule portion will have invented words. So moving on towards our main topic, which is unconventional trademarks, we will talk about traditional trademarks to see why you would have to understand non-traditional trademarks or unconventional trademarks. So It can be words or label. You can read both Xbox and Colgate in this, but they also have label where there are color combination. There is a yellow, there is a red, there is a white, there is blue. All these color combinations in Colgate give it the uniqueness of it. Similarly in Xbox as well. Next comes symbol. You won't have words at all. Of course, on the right side is Apple. The world knows it. This Mont Blanc. The pronunciation, the T is silent, but it is Mont Blanc. It's a European brand. Symbols can also be brands. You don't need to have words at all. And they need to be visibly distinctive. And then comes trade dress. When we say trade dress, there are multiple combinations in a trade dress. It can be a color combination, or in the case of shops also, when you see the bottom picture of the two restaurants called Taco Cabana and Two Pisos, one should study this case, which is very, very interesting. This is a case between two highway restaurants where in the US, you have to imagine highways are much more a way of life than in India. Most of them like to drive. And if you look from far on a highway, I'm giving you the mouse here on the left side. There was a restaurant which had two boards or three boards, one big board on the top, small board here, and then a lot of canopy around the building here, which was all copied by the other company, Two Pisos. So the court actually said, even without reading the word Taco Cabana, everyone would remember the outer shape of the restaurant, the outer canopies. All the restaurants look the same. Therefore, the other party who came out with a similar building, similar outer looks of the building was stopped from using it. So when we talk about trade dress, it is dressing the product or dressing the shop also. How do you dress it up? I mean, not just by word, but by shape, by color combination, and by different add-ons to the building as well. So non-conventional trademarks over a period of time became shape marks for the last 15-20 years. Chocolate companies like Kit Kat. Kit Kat was at least very popular in India, which is a wafer dipped in chocolate. And they had a lot of ridges in it, which will all be attached together, and you can take one ridge at a time, one plank of a chocolate at a time. Similarly, Toblerone, also, which is seen on the screen, has got a triangular shape, and they are all interconnected by chocolates again. But the triangular shape itself was protected. The outer carton and the shape of the chocolate itself is protected. So it can be a shape, it can be a color, it can be smell, it can be texture. We will look at further examples in a short while. So this Toblerone was registered as a 3D mark in Switzerland, as detailed on the screen today. And then comes just color marks. Another interesting fact is, imagine if you are in a village or in an agricultural background and you are looking at a tractor from far. Most of the Indian tractors are red in color. I don't know the reason why. Whether it is an Eicher tractor or it's a Mahindra tractor. Boringly, all of them are red, or uniformly everything is red. But the American company, John Deere, which came into India, has a very unique color combination of green and yellow. So you won't be able to see a tractor's name when you are seeing a tractor plowing a field half a kilometer away, but you will definitely see the green and yellow. So any other tractor which is in green and yellow will be perceived as John Deere tractor. Incidentally, John Deere also has harvesting, equipments which are probably 3 stories high. I don't know whether any one of you have seen it, but they are very interesting looking, larger than life equipments. And all of them are again green and yellow. So when there were competitors who started using green and yellow in India, John Deere went to the court, got an action filed for trademark violation, and they got a order of injunction stopping the parties from using the same color combination. Similarly, Starbucks has got its green dot registered. Tiffany has got a unique blue color which is also protected or can be protected, so on and so forth. So color marks, color is a very, very important aspect in a trademark violation. You might have different words, but if the same color combination is used, even though it is a different word used, you can still stop a person from using it. And another interesting case where I personally appeared in my previous role was getting a registration for the undersole or the bottom of the shoe in red color. So how do you protect the sole of a shoe in red color is how it is shown on the screen here. You will have a graphically represented CAD image showing only the sole as red, and any other shoemaker using red color on the sole of the shoe would be stopped from doing so. So, but it's controversial. Well, why I say it's controversial is there is no uniform protection for Christian Louboutin. Even in the home European office, there was a stiff objection to a single color being granted to a single owner. So, European Trademark Office, European IP Office has had differences of opinion in granting it. There was a refusal. He went on an appeal, and that case is still to be fully settled in one way or the other. But at least in India, the Delhi High Court stopped, had recognized single color and stopped a third party from copying it. We've had debates for the last 15-20 years whether you need a combination of colors or whether you need a single color is enough to claim monopoly. So in India, you might remember before Vodafone, there was a company called Hutch, and they had an orange color. Now Coke has a red color. Louboutin has a red color. John Deere has green color. So a single, and Cadbury has been trying desperately to register or enforce their rights on purple color. But I'm going to speak a bit more on Cadbury, the purple color. Not that I'm their lawyer, so I'm free to speak against them in a public forum. But interestingly, the purple color used by Cadbury has an interesting history. Any chocolate company, according to me, it's a personal thought, can use purple. Because if you see Hide and Seek, which is a popular brand of Britannia, if I'm not wrong, also has purple color. Because if you go to a coffee estate or a cocoa estate, and if you go to Coorg especially, you will see cocoa plantations there. And cocoa fruit, when you open the fruit, the first color you see in an open pod is actually purple. So when you scoop the cocoa seed out and then roast it like coffee roasting or coffee bean roasting. Then it becomes brown, and then you powder it, and then it becomes brown chocolate. But chocolate in its raw form is actually purple in color, and that's why for all chocolates, purple is very popular color. So it cannot be monopolized is what my understanding is. Similarly, in the US, the first time a single color was sought to be registered was way back in the 1950s. A company making fiberglass, went and registered this particular shade which you are seeing on the screen, which was for fiberglass. And they spent a lot of time, efforts, and money in educating the consumer that this color uniquely belongs to them. So they had to spend years and lot of time and money in educating the consumer. And of course, eventually they were successful in getting a registration. So, as I said, it can be a single color or combination of colors. Another interesting fact is when you have a very large consumer country like US, which is very brand conscious, the only way in which you can brand a banana is by dipping it in red ink, So what this Mexican Latin American country did was they will take the banana and dip it in red color so that in a marketplace their banana looks different, and that dipped red ink itself will be a brand for that company. So they went and protected it and registered it, saying that bananas dipped in red ink for an inch or two is their trademark or a brand name. So that is a very unique way of branding. There is no word in it, and you are actually coloring a natural product with an external surface of coloring. If one wants to actually know the entire basis on which Indian color combination works, please take time out to read this important case, a milestone case, which was argued by my former senior, Mr. Praveen Anand, on red and white color combination. You will have to understand, in a post-independence era, most of them will not call tooth powder or a toothpaste. For the longest time, 15-20 years, they will call it as Colgate. So the brand was so popular that the tooth powder will be Colgate only. They will probably mean Anchor, so get me a Anchor branded Colgate, things like that. So popular it was that anything which was red and white, they thought it was a tooth powder. Not understanding that it is actually a powerful trademark that Colgate had used. But there were multiple arguments against it, saying that the white and red is nothing but the tooth and the gum. The gum's color is red or pink, and the tooth's color is white or, many of our Indians don't have white teeth, but close enough. But eventually Colgate was successful, and Anchor agreed to add a third color so that they could continue to use, amongst others, red and white as well. So this is the citation. If one would like to see, it's freely available in many places like Manupatra. Please do read it. Then comes very last 7 to 10 years, things are moving towards smells as well. Unique smell to be protected as a trademark or a brand or a source identifier. More so when you can smell a thing and remember a place or a dish or a product, right? So you don't need to see the brand. You just need to smell the brand or smell the product. So on the right side, There is a description on the registration certificate which says non-visual play-doh scent mark. And under that is an explanation which says the mark is a scent of a sweet, slightly musky, vanilla fragrance with slight overtones of cherry combined with a smell of salted wheat-based dough. I mean, that's the most confusing explanation to a smell, but it is the owner who chose to actually describe the smell in a particular manner. I don't know. They've talked about musk. They've talked about vanilla. They've talked about cherry. They've talked about salt wheat-based dough. I don't know. It's a combination of 4 or 5 smells. It might probably smell like a bouquet of flowers, but it is what it is. And my colleagues also remind me that in UK, a tire company tried to register rose smell applied to vehicle tires. So, and also some have tried to register the smell of grass on a tennis ball. Possibly the players were not playing grass court. If they are playing in an artificial turf, they might remember smelling the tennis ball and believe that they are on a grass court and not an artificial court. So whether it is bitter beer or a bubblegum scent for footwear or erasers or flip-flop, persons have been quite innovative in bringing perfume scents to completely new products so that when you use it on a daily basis, those products remind you or remember or give you a pleasant experience. Next one is a German, the trademark office received an application, and it was for a chemical formula which was for a perfume. So as I said earlier, in the first few slides, we realized that a mark has to be unique, it cannot be generic, and it has to distinguish itself from others in the market. So the examples in the previous slide, we talked about Play-Doh, which smells of, vanilla, or the tennis ball smelling of grass, or tire smelling of rose. These tire, tennis ball, and the Play-Doh are all very items which you do not usually have a smell. You don't expect a tire to smell of rose or a ball to smell of grass. But this party, this one which we don't have a picture on, tried registering balsamically fruity with a slight hint of cinnamon. I mean, that's the one which is the explanation for a perfume. So a perfume will naturally have a smell, and you cannot register a particular smell because you will stop others from making a perfume of that smell. Therefore, it was refused. So if you see German Trademark Office and the European Court of Justice, both of them refused, saying that it is not sufficient enough to be registered. In India, it is quite early for us to say that this is what the trend is or this is what the registrations are. We don't have smell marks yet. The Indian Trademark Office is one of the most, fastest granting trademark offices in the world, while the US and EU, UK, and Australia take anywhere between 1.5 or 2 years from filing to registration. India Trademark Office is granting registrations anywhere between 6 to 10 months from filing. It's one of the fastest in the world, including a 4-month opposition window period. So you need to sit like a duck for those 4 months. Still, they are granting it in 6 to 8 months' time. So interestingly, there are many sound marks which have been registered in India. Graphically, this is how an audio is represented. This is again ICICI's corporate, song. And this is how a Tarzan shouts out, but this is exactly how it is registered in the Indian Trademark Office. So you need to actually show them graphically how the music is played so that it can be registered easily. And of late, they are starting to accept audio files also, which you and I can go online and play it. So what I played was Yahoo for you. That is Nokia. Next one would be that is MGM, the movie company. So all these are registered sound marks in India, which are updated both graphically and updated musically also in audio files. So next one is actually the bike company Harley Davidson. The bike has a very unique sounding silencer. And they had also registered the silencer sound before the trademark office. So in India, at least Enfield Bullet and RX100 have very unique sounds of their silencer. I mean, at least I'm a biker, so I know from far which bike is coming. Going back to the 3D mark, the shape over a period of time has made you remember that this shape belongs to Coca-Cola. You don't need a word Coca-Cola on it. No matter what the shape is. I mean, there is a series of shapes. Each of these shapes belong to Coke. Similarly, if someone comes from a foreign country, our relatives will buy invariably this Hershey's Kisses chocolate, which is in the shape of this teardrop, which we have kept in the middle. Both in the US and in India, they are being registered as a shape mark here. So that is also registerable and protectable. Similarly, in India, a cigarette lighter called Zippo, the shape of that unique looking lighter has also found protection and registration. And anyone who is misusing it has also been stopped by the Indian courts. So another thing which has been protected is the entire store itself. This was very commonly protected in the US. This store which you are seeing is actually a store. I would ask you to try and guess what store it could be. This is how they register the store layout in the US, but the actual store which they had visualized in the graphic representation is here. So it's an Apple store which typically, no matter where you go, will be the same, in the US at least. Similarly, what we did was in India, Godrej has a store called You and Us. If you see the brand name on the left side, they had a store layout. It's an interior design store. So you can go into the Godrej You and Us. They will help you design your house interior. But all the stores of You and Us look the same. So they had a chair of the advisor on the black color right side. They'll have a stand which will have miniature rooms here, and they'll have 3 chairs. So what we did was similar to what Apple did here, convert this actual store into a graphic representation. We converted this into a graphical representation, called this a TV, put a miniature stand, 3 chairs. This is a touchscreen TV, which is here, and a chair here, and we got it registered. So if you go online and search for Godrej store layout trademark registration, that is that is the first Indian store interior which was registered ever. Then comes fluid marks, which though they keep changing, the core of the mark is the same. It's something which you stare at it every day. For example, Google, which is called the Google Doodle, the original mark will remain the same. So if you see 74th Independence Day of India, you can see a lot of Indian art forms here, but you can also see a G, a O, a G here, L, and a E here, he. So the Google will keep changing every day. And for the Pac-Man's anniversary, they also made this Google Doodle. And that's something also is called a dynamic or a fluid trademark. And then comes the core remaining the same, but the packaging differing over a period of time. On the left is the vodka brand Absolute. They have celebration or anniversary packaging, where the main brand Absolute remains the same, but they celebrate some centenary or anniversary, which has been the iconic way of dynamic trademarking. They don't register all the packaging because they change it once in 3 months or 6 months. And similarly, KRIA is a very famous sparkling water company, and they kept IER from PERR, IER, but they changed the first few letters as flirtier, crazier, sexier, or sassier, but remained the same bottle, same shape, same bottom label, same cap, but just they played around with that to show their customers who are loyal that even though the branding is different, the source is the same. That's what even Amul does on a daily basis in India. They celebrate achievements, they convey news, but the Amul girl is always there, and the pun which they create around it is always there. So the way branding and the marketing works is good. So tell me that most of super brands during COVID also were playing around with either a face mask, or Volkswagen separated BMW, and Audi separated the rings and said, keep distance. We are still to confirm whether these are original company released branding, but at least a play around it. Last but not the least, I wanted to tell you that even individuals become trademarkable, or they have acquired distinctiveness, they have celebrity status or celebrity trademark which is protectable. Some of you who are old enough might remember this individual. He is now a playback singer. Back in the time, he was a Punjabi pop singer. At least in the late 90s and early 2000, he was extremely popular. Tell you what the case was about. This is Daler Mehendi. So Daler Mehendi had come out with a very popular song, and others started releasing a puppet, or actually a toy which looks like him. And when you switch on a switch underneath the toy, playing the same hit songs, Dardi Rab Rab. So the Delhi High Court actually realized that he has a personality right, he has a celebrity right to protect, and they actually stopped a company selling toys which look like him. So individuals were also protected of their celebrity status and personality rights as well. So we're just going to leave you with, once we have talked about so many different non-conventional trademarks, we thought we'll just leave you with the procedure for filing and granting registration. In India, registration is very straightforward. You file for the application. It goes into an examiner's table who will look for similar marks or say that it is descriptive or it is not registrable. Once that objection is cleared with a hearing, it will go into a journal or an advertisement. It is advertised means it goes into a public gazette for 4 months. If no one opposes it in 4 months, that is the opposition stage. If anyone opposes, then if the opposition is allowed, application gets rejected. If opposition is refused, then the application gets a 10-year period. So this is how an online filed trademark application looks. We filed it for an online crowdfunding for movie makers, right? And that's how a journal publication or a journal looks. This was published on 7th of June. So you can see 27th April, it was filed. Within 1.5 months, as in I was telling you how fast India works, 7th of June, it gets into the journal, and 27th October, it gets registered. This is a certificate of registration. So from April 2021 to October 2021, it's taken only under 6 months for it to get registered. So with that, our submissions, our presentation gets over.
Thank you so much, sir. And to begin with, it was such an insightful, presentation, because most of the stakeholders, they are not aware of the non-conventional trademarks. And that thanks to experts like you, and not anything from us. And it's great listening to you. Thank you, sir. Now I request my colleague, Mr. Srinivas Rao, to propose a formal vote of thanks. And incidentally, he is also a trademark attorney, sir. He did his LLM in intellectual property rights. He is assisting us in conducting this online lecture series. Over to you, Mr. Srinivas.
Thank you, Professor.
Thank you, sir. Thank you so much, sir.
Thank you, sir. Thank you for giving that brief. Thank you, sir, for attending this session. On behalf of DPIIT IPR-Chair OU Hyderabad, I would like to take this privilege for hosting vote of thanks. Sir, previous week we had a session on conventional trademarks. So wherein the speaker touched upon non-conventional marks as well. But today you have detailedly mentioned about non-conventional trademarks, and the way that you have chosen to present, it resembled like a virtual reality, in fact. So especially the introduction part with the picture on a shopping mall, and then picking up the brands in your daily life and correlating them with the trademarks. That was a nice presentation, sir. So in marketing and legal section also, you talked about generic marks, descriptive, suggestive, arbitrative, and inventive marks. And you also suggested the interests of marketing, how the legal points are asserted. Then you talked about the brands like Taco Cabana, 2 pesos for the branding in the form of their presentation, just nearby highways. And Cadbury's about its color marks, Apple store layout, Godrej India store layout, Google Dougal, and Absolute Vodka, Amul in form of fluid marks. And also you touched upon the celebrity or the personality trademarks. We like the case study of the Colgate for colors, the combination of the colors, and the Play-Doh for smell. Overall, the presentation was novel in many ways, and it was a clear knowledge and understanding for the participants, sir. So on behalf of DPIIT IPR Chair, OU Hyderabad, India, thank you, sir. Thank you for being here and giving this discourse. Thank you one and all for attending the session and making us to reach from strength to strengths. With this note, hope to see you once again, sir. Once again, everyone. And now we would like to conclude this session. Thank you for being, sir. Thank you.
Thank you. Thank you. Good evening, one and all. Bye-bye.